Judgment in the appeal of the Trustees of Olympic Airlines and Olympic Airlines SA.
Lord Sumption will explain the decision of the Court.
Olympic Airlines was the national airline of Greece until it went out of business in September 2009. The company is insolvent with a substantial deficiency. Under the law of the European Union, the primary jurisdiction for winding up a company is the country where it has its centre of main interests, or COMI in the jargon of insolvency practitioners. Accordingly, on the 2nd of October 2009, Olympic Airways was ordered to be wound up in Greece by the Athens Court of Appeal. Before it went out of business, Olympic had had employees in a number of locations in the United Kingdom for whom it established a pension fund. This pension fund has a large deficiency which Olympic is obliged under UK pension legislation to make good. If its insolvency prevents it from doing this, the pension fund will be entitled to claim against the Pension Protection Fund, a statutory compensation scheme for the United Kingdom. But it will only be entitled to claim compensation if it has been ordered to be wound up, if the company has been ordered to be wound up in the United Kingdom. Accordingly, the Pension Fund Trustees applied to the English High Court on the 20th of July 2010 for an order winding up Olympic Airways in the United Kingdom. The question which arises on this appeal is whether the English High Court has power to wind up a Greek company on that date if it was already being wound up in another EU country where its COMI was situated. Under the relevant European legislation, that depends on whether Olympic had an establishment in the United Kingdom. An establishment is defined for this purpose in the EU legislation as any place where the debtor carries out a non-transitory economic activity with human means and goods. On the date of the winding up petition, Olympic had only one remaining place of business in the United Kingdom, namely its former UK head office at 11 Conduit Street. So the question depends on what sort of activities were being carried out there at the time. The Chancellor of the High Court, who decided this case at first instance, found that by the time of the winding up petition, not much was happening at 11 Conduit Street. In summary, there were 3 people working there. They were assisting the Greek liquidator to wind up the company, mainly by dealing with the disposal of the few remaining business assets, such as low-value office equipment. They reconciled bank statements, they saw to the payment of rent and utility bills, they fielded telephone calls, and they referred matters requiring the attention of the liquidator in Greece to his staff there. In other words, they conducted the residual routine administration associated with the winding up of a company that was no longer carrying on business. The Chancellor considered that these activities were enough to constitute economic activity for the purposes of the regulation. Accordingly, he held that 11 Conduit Street was an establishment. It followed that the winding up petition was properly granted in July 2010. The Court of Appeal overruled him. The Supreme Court unanimously holds that the Court of Appeal was right and that the activities of the 3 remaining staff employed at 11 Conduit Street did not constitute economic activities. The reasons are given in a judgment which I have prepared. In summary, having regard to the context in which these words are used and the purpose of the provision, this Court is satisfied that economic activity means business dealings with the outside world and not simply acts of internal administration. A liquidator who carried on the company's business pending its disposal or who sold off its stock in trade might well be regarded as carrying on an economic activity. But those were not the activities carried on at the relevant time in 11 Conduit Street. The mere settlement of liabilities associated with the retention of some business assets, such as the lease of 11 Conduit Street, was not a sufficient basis on which to wind up a company in England when its COMI was elsewhere in the EU. The result is that the winding up order was not properly made in July 2010.